Is a court allowed to undertake reappraisal of the evidence that has been recorded by the arbitrator? Well, in case you don't know what reappraisal means, it simply means a reconsideration or a re-evaluation of the evidence that was presented by the parties before the arbitrator. And if you have heard the lecture before this one, then the answer to this should be very obvious to you. And of course, the answer is a big no. That is, the court cannot undertake reappraisal of evidence recorded by the arbitrator merely to discover the error or infirmity in the award. And infirmity simply means some sort of a discrepancy in the award. Now, this point itself is quite straightforward. However, I'm going to elaborate on it because there is a very important message that you need to understand from this point. So let's say that the arbitrator in reaching the award did make some sort of an error, okay? But as long as that error is not apparent on the face of the award, then the award itself is going to be valid and it will not be set aside. Why? Because the rule is that in order to set aside an award, that is, in order to claim that an award is invalid, the error should appear on the face of the award. That is, the error should be discoverable and it should be able to be discovered by the court simply by reading the award itself. So the court should not need to look beyond the award, that is to travel outside the award itself, and the court should be able to spot the error from the award itself. Otherwise, it's not going to be possible to contest the validity of the award in the court. And since this point is so important, I'm going to repeat it once more. The point is that if you think that there is an error in the award, then before you try to argue before the court that the award is invalid and should be set aside, you have to make sure that the error appears on the face of the award and that it should be easily discoverable by reading the award itself. So for example, if there is a situation where a party is trying to challenge an arbitrator's award with regard to the reasoning on the basis of which the arbitrator has reached the award, then that particular reasoning process which that particular party is relying on as a basis for challenging the award, then that particular issue with the reasoning process has to be apparent on the face of the award. That is, it has to be obvious in the award itself, and there should be no need at all to make reference to any material outside that particular award itself. So there is no straightforward rule regarding this. If there is, for instance, a situation where the court can see from the award itself that yes, definitely there was some sort of an error in the reasoning process of the award, but as long as that reasoning is made part of the award itself so that the court does not need to refer to any extra material, then in this situation it is possible that a party can challenge the reasoning behind the arbitrator's award, but the condition is that the reasoning also has to be established with reference to the material that is considered by the arbitrator in the award itself. So if it's not part of the award, then you cannot point fingers at the reasoning process at all. But if it is part of the award in some way, then you can challenge it as long as you can show the court that see, this is part of the award itself, and the court can then consider your challenge. Otherwise, of course, the general rule is that an arbitrator is the final judge in that matter and the court cannot review the decision on merits, that is, cannot review an award on merits and say whether the award is good or bad.